Welcome back to the Deep Dive, our Talk Testimonies listeners. Today we're going to be tackling another Supreme Court case, extracting all the key insights just for you. And the case we're diving into today, it's Kisor v. Wilkie. This one really grapples with how much deference courts should give to those interpretations of regulations made by administrative agencies, specifically in this case, the VA, the Department of Veterans Affairs. So we're dealing with this big question before the Supreme Court. Should they overturn or at least limit this thing called the Auer deference doctrine, which basically says courts got to defer to an agency's interpretation of its own regulations, especially when those regulations are a little bit, ambiguous. We're going to unpack the court's decision and then really get into the arguments that got us there.
Yeah, so the Supreme Court, they decided not to completely overturn Auer deference. What they did was more like a confirmation, but with some pretty strong caveats. The court said, look, this doctrine's staying, but courts got to do their due diligence. They have to go through this rigorous analysis to figure out if a regulation is truly ambiguous before they even think about bowing to the agency's reading of it. They actually kicked the Kisor case back down to the federal circuit to be reconsidered with these, stricter guidelines. So Auer deference is still around, but its reach has definitely been narrowed.
Got it. So Kisor, the person who brought the case, they wanted to see Auer deference gone completely. It's kind of interesting. The government, at least in this specific case, seemed to agree that deference wasn't really called for in Kisor's particular situation. Can you break down Kisor's main argument against Auer deference? What were they really driving at?
Sure. Kisor's biggest issue with Auer deference was this idea of democratic accountability. When agencies make what we call interpretive rules, basically their own understanding of regulations that are already on the books, they don't have to follow the same public notice and comment process that they would for, let's say, legislative rules. Legislative rules carry the force of law. And Kisor argued that this lack of public input, it's a big problem when it comes to interpretive rules. They thought courts should instead use something called Skidmore deference. Instead of automatically siding with the agency's view under Skidmore, the court would only give weight to the agency's take if they found it persuasive based on its merits. How strong is the argument, regardless of who's making it?
Right. So it's not just about who's saying it, it's about the quality of the reasoning. Did Kisor raise any other points against Auer deference that really stood out?
Oh, definitely. Kisor also brought up this concern about instability and fairness, especially when agencies can just change their interpretation of these regulations without any public input, without any real accountability. They even brought up the Marsh case as a prime example of how this can create so much uncertainty for people who are actually affected by these regulations. Plus, they said this legal principle of stare decisis, the idea that we should stick to established precedents, it shouldn't apply as strongly here because our deference to them didn't really have a strong original justification. And actually, they argued it leads to more instability down the road. Kisor also pointed to the APA, the Administrative Procedure Act. They argued that the APA reflects Congress's intent that when agencies make policy, it should usually involve transparency and public participation, so those agencies are truly accountable to the people.
So Kisor's position was that agencies could essentially pull a switcheroo on how they interpret rules without any real checks and balances. How did the government, representing Secretary Wilkie, respond to these criticisms?
Well, the government did admit there might be some issues with Auer deference, but they still fought hard to keep it around, at least for its core applications. They really stressed instances where an agency had been super clear and consistent about its interpretation over time. And they highlighted the perks of sticking with Auer and its predecessor, Seminole Rock. They said it helps ensure regulations are applied the same way across the board, it creates predictability for everyone involved, and it makes things more politically accountable because the power to interpret these complex rules is with one agency. It streamlines things.
So they emphasized the practical benefits of having that central interpretive authority. But did they basically just say, ours perfect, leave it alone?
No, not exactly. I mean, they knew their criticisms. So they actually came up with this multi-part test that courts would need to use before they even thought about deferring to an agency. This test, it had all these different factors, like, first of all, is the regulation truly ambiguous? Is the agency's interpretation even reasonable? Has it been consistently applied? Did this interpretation come from high up in the agency? Did everyone have fair notice of this interpretation? And does the agency even have expertise in this area? They did admit, though, that judges often disagree on whether a regulation is even ambiguous in the first place.
That sounds like a pretty big checklist.
Yeah.
What about Kisor's point about public notice and comment being so important for democratic accountability? How did the government counter that?
The government basically said, look, notice and comment, that's great for legislative rulemaking, but it would be crazy to do that for every single interpretation an agency has to make. It would just bog things down. They also brought up Seminole Rock, the case that kind of paved the way for Auer. They argued that when Congress gives rulemaking power to these agencies, it's implied that courts should defer to those agencies when they reasonably interpret those rules. And specifically, in the Kisor case itself, they said the Federal Circuit was way too quick to say the regulation was ambiguous. And they argued that the decision from the VA Board of Veterans' Appeals, it didn't necessarily reflect the whole VA's official position, especially given how the VA is structured and how it makes decisions. They even went as far as to say that their own interpretation of the regulation, well, it was just the more sensible one. And if that's true, this whole veterans canon idea, where you interpret laws in favor of veterans, wouldn't even apply.
Interesting. So they were defending Auer as a concept, but saying it shouldn't have applied in Kisor's case. Let's move on to Justice Kagan. She wrote the majority opinion. How did the court finally settle this debate?
Justice Kagan, she did reaffirm this idea of Auer deference, but she put some real limits on it. She said, okay, courts have to do their homework first. They got to use every tool in the statutory and regulatory interpretation toolbox. They have to look at the actual words, the structure of the regulation, the historical context, even its intended purpose. They have to be absolutely sure that there's a genuine ambiguity before they even think about deferring. Deference, she said, is only justified if, after all that digging, the regulation is still unclear and the agency's interpretation, it has to be reasonable.
So courts can't just wave the ambiguity flag and call it a day. They got to really put in the work to interpret the regulation themselves.
Absolutely. Justice Kagan was very clear that Auer deference, it's not something you just do automatically. Courts have a responsibility to interpret the law. That's their job. She did acknowledge all the arguments against Auer, but in the end, she said, look, we have to respect precedent. Stare decisis, remember. That carries a lot of weight, especially since Auer deference has been a part of administrative law for a long time. But she also pointed out the practical benefits of sometimes letting agencies, with their specialized knowledge, clear up ambiguities in their own rules. Think about stuff like, technical regulations or things that are really policy heavy. It makes sense for those who know the area best to weigh in.
And what about this worry that agencies might intentionally make regulations vague just so they can have more power?
Right. Justice Kagan addressed that head on. She said, we haven't seen much evidence of that happening. She also emphasized that the judiciary, they have this crucial independent role in interpreting the law, and using Auer deference can't ever mess with that basic separation of powers. She even gave some solid examples of areas where agency interpretation is often necessary because things are just super complicated, like the ADA and its accessibility guidelines, TSA rules about what you can bring on a plane, stuff from the Mine Safety and Health Administration about how to diagnose things, and FDA definitions about what's considered an active pharmaceutical ingredient. It gets really complex, and sometimes you need that expert insight.
Okay, so it sounds like the court tried to find a middle ground. Auer deference stays, but it's got these new, stricter rules really emphasizing that courts need to take the lead on interpretation. Now, for our 10th chair segment, let's shift gears a little. I want to hear your perspective. After really digging into this case, what's your take on the outcome?
All right, so if I'm sitting in that 10th chair on the court, I gotta say, I mostly agree with the majority opinion. Those arguments against Auer, the ones about keeping agencies in check and worrying about them having too much power, those are valid points. They raise serious questions about who really gets to call the shots in our system. But I can also see the potential issues if we just tossed out deference completely. Think about it. All those ambiguous regulations would land squarely on the court's laps. And we could end up with inconsistent rulings and maybe even some bad decisions because, let's face it, courts aren't experts in every single field that agencies deal with.
Right. Courts can't be expected to have that deep, specialized knowledge in every area.
Exactly. And that's why this idea of having courts really scrutinize a regulation before they even consider deference, that makes a lot of sense to me. It gets at the heart of the problem. Sometimes courts might have been too quick to defer without really grappling with the regulation itself, understanding its context, all of that. This new approach, it still respects the court's primary role, which is interpreting the law, but it recognizes that agencies have a lot of practical knowledge and experience with these regulations. And the fact that the Supreme Court sent Kisor back to the Federal Circuit, that speaks volumes. It tells the lower court, hey, you got to really dig deep and figure out if this VA regulation is actually ambiguous before you even think about deferring to the agency. This new emphasis on that initial interpretation by the courts, I think it's a smart move. It's a way to ensure that agencies are held accountable, but it's also realistic about how complex these regulations can be.
So a decision that tries to find that balance, making sure the courts are doing their job while acknowledging that agencies have real expertise that we need. Well, that wraps up our deep dive into Kisor v. Wilkie. For all our Talk Testimonies listeners out there, we hope this gave you a clearer picture of this case and what it means for how courts and agencies interact.
This case really highlights how important it is to think about the balance between expertise and oversight. It's something that affects all of us because these regulations, they shape our lives in so many ways.
We always love to hear what you think. What's your take on how much deference courts should give to administrative agencies? Did the court get it right in Kisor v. Wilkie? Keep thinking about these issues. They matter.
And be sure to join us next time on The Deep Dive, when we'll take on another fascinating legal challenge, bringing you all the insights you need.